कोई दचता रहे भाई क्या बात है।
I raise my voice not so that I can shout, but so that those without a voice can be heard. Greetings of the day, everyone. On the behalf of Delhi Judicial Reforms Council, I extend a warm welcome to the esteemed speaker and the participants who have taken this platform as an opportunity to attend a discussion on Bilkis Bano, the win, the verdict, and justice. Delhi Judicial Reforms Council have been formed under the National Judicial Reforms Council under aegis of WICCI, that is Women's India Chamber of Commerce and Industry, is a women-run initiative. The council has been working for the betterment and upliftment of society by addressing core issues that surround society. Before we start with the discussion, let us understand what makes this judgment historic. The Supreme Court's landmark decision on January 8, 2024 in the Bilkis Bano case is pivotal victory for justice, nullifying the Gujarat government's leniency towards 11 convicts involved in her 2002 gang rape and families murdered during the riots, establishes a crucial precedent for human rights protection. Join us for a detailed discussion on this legal milestone featuring insights from the victim's advocate, the person who's behind this historic win, exploring its implications for human rights advocacy and broader legal landscape. To begin, I would like to invite Ms. Shreya Singh, Vice President of Delhi Judicial Reforms Council, to give the welcome address. The President of the Delhi Judicial Reforms Council, Shreya Singh, is also a respected advocate. She has been with the Council for many years and has gained a lot of experience. Her journey from being a council member in NJRC to the Vice President of DJRC has been exciting and rewarding. Over to you, Shreya.
Thank you, Bhumika. We believe that every voice deserves to be heard, and this case is a powerful example of seeking truth and delivering justice. A very good evening to everyone. I hope you all are doing well. I, Shreya Singh, the Vice President of Delhi Judicial Reforms Council, is truly honored to welcome Advocate Shobha Gupta ma'am on us. Advocate Shobha Gupta ma'am, she has been serving as the momentous in the case of Bilkis Bano, the win, the verdict, and the justice. The case stands as a shining example of the power of perseverance and pursuit of justice. It's a testament of the unwavering commitment of Advocate Chopra Gupta ma'am, who played a pivotal role in fighting for the justice. Her expertise will undoubtedly contribute to our ongoing efforts and to reform and strengthen the judicial system. Thank you.
It is now time to invite our special guest of this evening, Senior Advocate Ms. Shobha Gupta. Advocate Shobha Gupta is a seasoned legal professional with 25 years of practice in the Rajasthan High Court, Jaipur bench, and 23 years in the Supreme Court. specializing in diverse legal domains such as PILs, constitutional cases, civil disputes, criminal matters, and more. She has represented notable entities like the Rajasthan State Electricity Board and National Small Industries Corporation Limited, with over 16 years as a standing counsel for the National Human Rights Commission. She has also served as a panel lawyer for various government organizations. Recently, she has been designated as a senior advocate by the Honorable Supreme Court of India. We welcome you, ma'am. I request Shobha Gupta, ma'am, to bestow her wisdom and share her valuable insights. Over to you, ma'am.
Good evening to all. And I switched on my mic and video. I would expect all the viewers also to let me have the pleasure of seeing them. And Bhumika and Shreya, what do you want me to do? Like just keep going on, or you people are actually asking questions and I'm talking?
Ma'am, like the way you can start, you can just tell something about the case and guide us.
So it's always good for these kind of matters for a question answer forum type kind of thing. You people are asking, I'm seeing, but I'll just start on with that. So the matter is, you all know the facts broadly. You all know. It came to me when I was only 7 years old in the profession and 5 years old in Supreme Court as a lawyer. I became advocate on record by that time. For you, most of you must be knowing that to become an advocate, to file matters in Supreme Court, you necessarily have to be an advocate on record. And to become an advocate on record, you have to have 5 years of practice. You have to undergo a training of 1 year with an advocate on record, like one who is already advocate on record. Once you complete the training, then you submit the certificate and then you can appear in the written examination. Once you appear in the written examination, clear that, then you become entitled to it. This is, a distinction given to the lawyers. Not everybody can file in Supreme Court. And I always say, clearing or not, but preparing for AOR exam, that advocate on record exam is in itself is, an achievement. It makes you a different lawyer. It makes you, at least for that age, a very complete lawyer. It makes you learn the do's and don'ts to be a lawyer and the practice ethics to be followed. And I've also noticed in my practice that lawyers who do clear the AOR exam, broadly, by and large, following some principles. So that is some distinction, this particular designation does bring to you. Designation in terms of AOR. Now, coming to this Bilkis matter. So, Justice Anand was Justice A.S. Anand, the then Chief Justice of India. He just retired and became the chairperson of NHRC. When this incident happened, the Gujarat riots happened and so many persons suffered the atrocities at the hands of the perpetrators. There were mayhem. The relief camps were there. National Human Rights Commission as the high-powered commission for protection of human rights sent their delegations, and most of the time the then chairperson, Justice Verma, visited the camps. So they met Bilkis also in the relief camp, and Bilkis was made to submit her say, whatever she had gone through and what she wants now to be followed up and other things, to all of them, including NHRC. And NHRC then took a note that possibly this is one case where they might have to render assistance. But since the matter was then going on, some FIR was registered and the matter had to go on before the investigating agency for the purpose of investigation. Possibly at that point of time, the NHRC had no role to play. But unfortunately, what happened that though Bilkis has given names of all the accused, why? Because she had been brought up amongst them. They were her immediate neighbors at her parental home. And at that unfortunate time, she had visited her father, and from there only then when this Godhra train carnage had taken place and Muslims were being attacked and they had started running to save their lives. So Bilkis and like almost the entire village was running. All the villagers, Muslim villages, all villagers were running from places to places. So Bilkis and family members, they were like some 15, 16 odd people. They started running, and in fact, the group divided into two, three groups. Few ran one side, and others ran other direction. So 16 of them were running with like they were shifting from places to places, like staying for a few hours at one place, then maybe a day at another place, then they went to another village. So they were just to save their lives. They were shifting places going forward. This particular night, they were passing through the forest area, and there they were attacked by and these perpetrators were mad people at that point of time, and they were looking for the Muslims to take revenge or maybe to kill them, or God knows what was the idea was, but there was a like bloodthirsty follow up. And they when they were just roaming around, they found this 14, 16 people and they attacked them brutally. And brutally not only killed everyone but raped the females. Our case was that they gang raped more than three, but on facts, we could establish three women were gang raped. And all of them murdered, including those two women. Bilkis could survive as they thought she has died, but she had, you know, she collapsed all because of all torture she was receiving, but life was left in her. She would have killed, but that was possibly a judgment error by the perpetrators, by her assailants. So you people are so young. I don't want to even say all that gory details, but like you must have all seen, read about it. Her daughter, the first delivered child, Bilkis was only 21 then. Her first delivered child was just took and smashed. Her head was smashed on a stone in front of her eyes. She kept pleading, but then she was gang raped, and she was 5 months pregnant. Her mother was gang raped and killed in like in and she was made to witness that whatever she could, because later on she became unconscious. A cousin who became mother just a day before, while they were running for their life, and she was pregnant, full-time pregnant, so she delivered a baby somewhere during that escape attempt only. Bilkis's two minor sisters, her two minor brothers, Fufa, Fufi, Mama, two more cousins, all were killed. And the murders were brutal. They were not gunshot. They were not, uh, by strangulating. The dead bodies show that they were actually killed by heavy stones thrown or pushed upon them. So their chests were pressed, compressed. Some dead bodies show that brain material was out. Like they were like inhuman brutality. What do I say? Barbaric, stone era kind of things. So she regained her consciousness somewhere late in the night or early in the morning. She found everybody dead in dark night. She had no clothes over her also. So she pulled out clothes from the dead bodies, then went up to the hill. From there, she kept waiting for sun to rise, some light. Then she went to a nearby village where she found some Adivasi lady. She narrated what had happened to her, and then that Adivasi lady had given some clothes to Bilkis to hide her, and even to hide the identity. She came back to the hilltop, and There, some police person, they were just doing that rounds. So he took her to the relief camp. Relief camp, she came, she disclosed, she narrated everything. But unfortunately, the police person, the who attended her, did not note the details properly, and rather attempted a deliberate attempt was made to goof up. And he had not mentioned the names of the perpetrators. Then he said some 400, 500 people came in two jeeps, which was an impossibility. So the idea was to write a complaint which is very unbelievable, and finally to close it and close the matter, which possibly had happened with many of the Gujarat raid cases. In her case, the fortunate part was when she was in relief camp, a district collector, Jayanti Ravi, she visited the camp with her associate district magistrate, I believe. She noted down all the details. She made that her assistant to note down all the details by hand then and there. And coming back to office, she got all that typed and sent it to the police commissioner. And 2 days have been passed by, no medical has been done. No medical has been done for the purpose of rape allegations. And so the follow-up was done. Bilkis was, then her postmortem was done. Her medical was done. FIR was registered. But since there were no names mentioned and other things, so it was finally on the police submitted that a closure report and requested the magistrate to close the FIR, and magistrate had also allowed. At this juncture, NHRC, when the NHRC came to know this development, they have the then chairperson contacted me through some lawyer. They were just looking for a lawyer who can do it fearlessly and would not succumb by pressure, or would not be surrendering or leaving the things in between. Somehow they thought I would be a person who would not be getting would not be succumbing to the pressure which would come to me. They asked me to file a writ petition. We filed the writ petition, and from there the journey began, where the Supreme Court initially on our first petition gave the investigation to CBI. CBI did a fab job, exceptionally good job, because from a dad case, so many months passed by, everything was completely tempered, finished, done away. So much so that the dead bodies were, displaced. They were removed from the place of occurrence to somewhere else. So many dead bodies were missing, just to say that her story is unbelievable. She is not making correct statement. So till date, Bilkis could not find her daughter's dead body. She could not do the last rites till date. Then the remaining body, whatever they had, 7 and 8 bodies, they took them to nearby a river body, and they asked few villagers to come. They got a very deep, they asked them to dig out land and stuffed all the dead bodies there, purchased 90 kgs of salt, put salt over there so that everything goes away. And if at all somebody digging it out and doing something, and they would be finding nothing. But God has his own plans, when you do all this. So when CBI came into charge, CBI actually could lay hands to the photographs then clicked, where all the dead bodies were seen. And then when they started doing their investigation, they could reach to this place. They then opened up that dug, and they found these skeletons. You won't believe, the clothes were still intact. So somehow the enormity or enormous quantity of the salt did a reverse, that they preserved the all these articles, so bangles, slippers, clothes, so many things were still intact. So this is how one could relate that this skeleton appears to be of that person, and and then other things were done. Then CBI filed their charge sheet. Charge sheet was a great job. We again came to Supreme Court and we asked that now we do not have any hope with Gujarat police to do, or Gujarat police to now do a good job in trial. And then trial court judges might also be pressurized as they have earlier closed the case. So let it go to some other place. And the court immediately agreed. They sent the matter to Maharashtra Special Court. Then conviction in 2008. The though the police, 6 of the police persons were made accused in the matter, and 2 of the doctors who did not do the postmortem. So you won't believe that when there are allegations of this nature, the bodies were of the shape like they had white fluid coming out from their private parts. Uh, they were like nostrils, eyes, blood was coming out from eyes. Despite all that, the postmortem report says no major injury found. There was not even a whisper about bodies reflecting, or some it appears that they have been gang raped or raped. Nothing of the sort. They were very simple postmortem reports. So even those 2 doctors were made accused. Trial court did not punish, did not convict the doctors and the police persons, except the one who wrote the FIR, the complaint, because that was on face of it. And because of Jayanti Ravi's details and 2-3 other places Bilkis mentioned, so it was very clear that to whomsoever she was narrating her story, she was giving the very same story with all detailing, names, everything to everyone. Why would she miss out to that police person? Now, that police person, when she was naming, he told her that don't give the names of these persons. If you continue to pursue or give names, we would give you a poison injection. Now, when he was saying this, other relief camp persons actually heard that. So they became witness that it's not only Bilkis's allegation, but we have heard that. We were standing on the door and we were hearing all this, we were witnessing all this. This way, but one police person, he was convicted by the trial court. But High Court, when CBI challenged that order of not convicting the police officials and the doctors, High Court found force in the case of CBI, and High Court convicted all the rest of the police persons and the doctors too. So this is our 20 convictions. One died, so 19 convictions. Supreme Court, when they came, Supreme Court said, you have been let go very easily. No, so they did not even entertain. On the day one, they dismissed their appeals. So this is how the matter reached to the finality in terms of the conviction. We were already, a battle was on since 2003. Since then, we had a battle on regarding a compensation or damages to be paid by state because of for the, glaring failure on the part of the state on so many counts. So this battle we won in 2019 when the court had granted us the compensation or the damages against the state, which was highest ever in such cases. Which is 50 lakhs monetary relief, compensation of 50 lakhs rupees. They directed the state to provide an accommodation and also that she be given a job of her choice. Now she is illiterate, so she could not have get any job but to a class D. But then Bilkis had a huge fear psychosis to, be amongst strangers and to be out of a comfort of a home, like the security of a home. So she refused to take the job. We suggested her husband be given, but that has not been worked out yet. Accommodation to an extent they have given in terms of she had to take at the very place where she was living, and there was no government accommodation available. So they offered land which Bilkis had taken. They hadn't given any amount to construct the house. So I believe then she had started constructing that with that 50 lakhs, which was a compensation given to her. So that I would say a piecemeal compliance or maybe part compliance, not full compliance of that order. So far so good. Now they started living at one place in place of running from one place to another place to save their lives, and for last 17 years they were doing this only. No proper education to the children, no source of income, nothing. But when this finality has arrived, so 2019 compensation thing took place, then they started living at one place, stability, children started going to a regular schooling. But only that was possibly a very a short lasting thing, as in 2022 we faced that remission order, and remission order came as a shocking not only shock, but how do I say it? It was, a cheating on her by the state, in terms like she was never discussed, informed, told. Her security concerns were asked, and how would the remission react on her? Nothing was asked from her. She was not consulted. She was not discussed with. She was not informed. Nothing. Like any one of us could know, get to know. She also came to know on 15th of August 2022 that her perpetrators, and not one and two, but all in bulk, 11 of them would be roaming around in the same village. So that was a completely turnaround of things, which nobody of us expected actually. Maybe that was a short-sightedness by us as lawyers, that it didn't occur to us that something like that would happen. Criminals of this nature would be allowed to come out, and within 2-3 years of what we thought has attained finality. In my career, I've never seen my, if the accused have appeared and they would be like coming 2-3 years down the line, man, we are here, don't worry. I've not seen that happening. So, and it's not a regular feature that accused are coming out within 2-3 years of condemnation. Anyway, so that has to be another battle. It was very unfortunate time, and very depressing time in terms. It was difficult to face Bilkis, to tell her, so what, we won from all courts. So what, we got the highest compensation. So what, the court was always with us. But the very state where you live, you have been you have been you took birth, and you have been there all along, had never been with you, and they have once more ditched you. Anyways, we told her, and she said, "Ladna to ho gayi hai, baby. We can't let that happen. We can't let that happen." We all were clear that you cannot let that happen. That you cannot let that last longer. But my idea was that it has to be a fight by all. It cannot be left on the shoulders of Bilkis. It cannot be like, so your fight. We would cry along with you. We would provide you a shoulder, but that's your fight. You fight, and we would only be bystanders or maybe supporting you. I thought it's a time where society is saying it's our fight, and we will fight it out. So I actually called upon from all my TV interviews and other things. I said, why should she take up? When people were asking me, the journalists were asking me, so are you going to challenge that? I said, why are you asking me? You are part of the society. Why don't you go and challenge that? Why don't the society get up and go and challenge that? Assume for a moment Bilkis says, I'm okay with that. Or I would go and hiding. I'll leave the country and go and live somewhere else. Are you the society? Are you as a society okay with the fact that criminals of this nature, of that extent, who can commit a crime of this nature, would come out and live around? And luckily, so many public spirited individuals, they filed petitions. And Supreme Court entertained that, issued notice. So later on, yes, in the final verdict, they said we are not saying anything about the maintainability, but they entertained those petitions. And yes, Bilkis had joined hands later on, because he had to at any event come in the bandwagon. And secondly, they were raising objections about the maintainability of those PILs. So it was all the more necessary for Bilkis to join. The order, since I've seen the papers of remission, they had applied no law. They had completely given a go by to the requirement of law, which says these are the factors, the nature of the crime, the impact on the witness, impact on the victim, the possible impact on the society, uh, would all have to be seen. Nothing like they had taken no labor. The orders were very simple. Their conduct has been good in jail, and therefore let them come out. They have completed 14 years. Their conduct was good, so let them come out. Which was stating on the face of the law of remission the factors which needed to be there. And then the major issue was that Gujarat government is not the appropriate government, which unfortunately Supreme Court in its order of May 22 said Gujarat government is the appropriate government, and that was completely a contrary view than Section 432(7) CRPC 432 subsection 7, and many of the judgments, M.T. Khan, Ratan Singh, then B. Sriharan, and number of judgments. There are many judgments of that nature, which says like at least 5 we cited, which clearly says so what the crime had happened at place A, but if the trial has been conducted at place B, then the state where the place B is situated would be the appropriate government. The government of that state would be the appropriate government, and not the government of the state where the crime has taken place. So the section was clear and the law was clear. So unfortunately, the order of Supreme Court was bad in terms it was per inquiry to the settled position of law and the provisions of law and the settled situation of law. So settled position of law. That two parts. And third is that order was also bad as obtained fraudulently. So it was a nullity. Fraudulent in terms that the convict who had gone to Supreme Court under Article 32 petition did not say that there is already a judicial order against me saying Maharashtra is the appropriate government. And therefore, he actually filed his application before Maharashtra government. Now, that was a judicial order. Either you live by that or you challenge it. For a High Court order to be challenged, the only remedy is to file SLP before Supreme Court. If that is a criminal court, there is no provision of appeal, intra-court appeal in High Court for criminal matters. So the remedy available to him was to file a special petition. The law is well settled. Naresh Kumar Mirajkar, you all must read. That is a nine judges bench judgment. Thereafter, Rupa Ashokura, that is 5 judges bench judgment, which clearly says, following Naresh Mirajkar, that a judicial order cannot be challenged by way of Article 32 petition. So that's not maintainable. So that was even contrary to that position of law, that 13th May order, 13th May 2022 order. So when we challenged the remission and we argued this, court, it prevailed over to court. In fact, every single argument of us was prevailed over to court. Like this is one aspect, that order is nullity. Appropriate government would only be Maharashtra. If Maharashtra is the appropriate government, then the Maharashtra policy would apply. A very interesting point was that none of these convicts had paid their fine. You all know that in our penal jurisprudence, in all sections of IPC, you would find that most of them says X amount of imprisonment and fine, or either of it maybe, or both of it. Depends section to section. So if the court is saying undergo imprisonment for a number of years, like in this case, it was a life imprisonment, and they say a fine of rupees 2,000 for one offense. For another offense, they had, so likewise, they had, I believe, 6,000 or more fine in each case. In default sentence for each case was, for each accused was 6 years. The law says that those sentences of in default which one has to undergo cannot be adjusted into minimum sentence undergone for the purpose of remission. So these are it has to be undergone additionally the substantive sentence. So assume your policy says minimum 14 years sentence undergone, you can apply for remission. But that 14 years would not have that 6 years within it. The 6 years period in default would have to be undergone separately in addition. Therefore, since they have not paid the fine, in their case, it becomes 14 plus 6. So minimum 20 years they had to undergo, which wasn't also done in this case. So for all these reasons, court had seen there was no application of mind, no factors applied. So the remission order was mechanical, no application of mind. The Gujarat government had no authority, so usurpation of power. They had not even undergone minimum sentence, even as per their own policy. And that even central government, when they approved the Gujarat government decision, that was again mechanically without application of mind. That was a 4-line order common for all. So keeping all that in mind, court had cancelled the remission, and they said that their staying out on remission for 17 months post 13th May order was illegal, and therefore them to stay out even for a day is illegal. They have to go back, and that's why they were asked to surrender. And then again, then everybody knows that they wanted some extension of time, but the court said sorry, and I am so glad court said so, because it would have otherwise sent a very negative impression amongst the public that okay, finally manage हो जाता है. वो मैनेज नहीं भी होता, कोर्ट अपनी तरफ से लीनियंसी दिखा देती, पर फिर इंप्रेशन ये आता अच्छा सा मैनेज हो जाता. तो आई एम ग्लैड court has shown no mercy and said no nonsense, now please go and surrender. Their grounds were also very silly. Like someone said, I have 2 sons, parents, my one son is out, I'm the only person who have to take care of it, and I have to make financial arrangements. What, like, this is no ground. Somebody says my crops are ready, I have to cut them. No ground. Somebody says my leg was amputated, and the leg was amputated some 20 years back, even before the time was committed. So otherwise also the grounds were like very, very silly grounds. No one could have actually thought of giving any mercy, because they were not even calling for. They were very make-believe, very, just you do something just for the sake of it kind of applications. So this is all about it. Then they surrendered, and that's it.
Ma'am, we have a few questions from our participants.
Yeah, they were flashing. I could read them.
Yes, ma'am. Yes, ma'am. So, ma'am, one of them is, has this case ever affected you in terms of handling future cases?
How does that happen? But so none of your case can affect you adversely to handle your future cases. For me, my future never happened after this matter, because I was always in the matter. They never allowed me to have a future beyond it, because when I was only 7 years old in the profession, since then I'm handling this since 2003. Until date, I'm handling this matter. I do not know tomorrow there would be review petitions, then curative petitions, then something else. Luckily, now they cannot file any remission application for another 14 years, because the minimum minimum imprisonment to be undergone for in Maharashtra policy for all these offences: gang rape, killing minors, mass murders, gang rape and murder, gang raping a pregnant woman, for all these they have 28 years minimum. In some states, luckily they have exclusion for such crimes. Unfortunately, Maharashtra does not have the exclusion, but Gujarat has exclusion for these things in their 2014 policy. But Maharashtra now minimum 28 years, so they cannot immediately file any remission. But I have had no future beyond this matter, because this matter always lived with me, or I lived with this matter all along. It might have made a difference in terms of making me a more sensitive person, possibly. Not only this matter, the facts are very gory in this one. I've been unfortunate one to have handled another matter which had again very gory details, and that's Manorma. You, as a law student, you all must read once Manorma details. As you mentioned that I have been a National Human Rights Standing Council for last now 21 years. Since 2003, I'm their counsel, so I have dealt with all sorts of cases. Manorma, the details were like very, 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 very hair raising. Again, like Bilkis case, whenever I read it, used to be a difficult time for 2 days. You know, it's difficult whenever, even when I'm talking, it is difficult to not to live the moment and live the pain. Manorma again, horrible facts. So these kind of matters, you know, can have both kind of effect. You can get into a shell, or you might become very vocal, very no, zero tolerant person, such crime, in any kind of injustice to women. Though I've seen all along, like my mother is a rock star, so I've seen this in my family that no nonsense to be tolerated, and very up for raising voice against any injustice, anywhere to anyone. So maybe, but I believe I have lately started believing that this case must have played a role in my mind, must have, you know, played a role in making me a certain person. I run an organization in the name of We the Women, where I work for women empowerment and I help the women in need. I provide them pro bono services, look for their education if somebody needs, look for whatever under the sky they need. So a lawyer, much more senior than me, we were having a webinar during COVID periods, and we all were there like we are today on a screen. And we were talking some subject, and he just pushed a message to me. He said, like, why, like, you do all these things? Can I ask you a personal question? Have you personally suffered something? And you know, it was difficult to even understand that question. I said, my God, so that's why we have a society like that. That's why we have men around us who can torture women, who can be so unjust to women. That you have to ask this, to be sensitive against crime, to be sensitive against injustice, to ask for equality, to ask for, like, I have a slogan, equal and respectful space. Okay. Why you have to personally suffer something to be sensitive and to be, you know, conscious of this, right? But lately I understand maybe this case, this long lasting case on me might have had an effect.
Thank you, ma'am. That was a really insightful answer. And the next question is Bilkis Bano case and remission, government policies and interventions for development in various sectors, and issues arising out of their design and implementation. Kindly give insights on this.
So you need to read this question again.
Yes, ma'am. I think there is some problem in the.
I didn't get that. I thought by the end I would be able to understand the question. Yeah.
Bilkis Bano case and remission, government policies and interventions for development in various sectors, and issues arising out of their design and implementation. Kindly give
Who is
insight.
asking this?
Shivani Gupta.
Shivani, why don't you speak your question clearly? Is there?
Shivani.
She's not unable to turn my mic.
Bhumika, take the last question. I think that's the same only what she's asking. Someone has asked a similar question. Take that one.
Ma'am, what about the remission plea for Maharashtra government regarding this case?
I think I just told you that Maharashtra, they have the minimum period undergone requirement is 28 years for these offenses, which are, in Bilkis's case. So for them to be eligible, become eligible to apply under Maharashtra policy, they would have to wait for some it would be 14 years, some it would be 15 years, depending on who enjoyed what furlough and parole. So, but minimum at least, I believe at least 13 more years they would have to stay inside to be able to exercise it. Again, I'm saying it would be very how many years they have undergone uh, with including the remission. Otherwise, you have two kind of remission. One is you exercise under 432, and another one is as per your jail manual, which you have become entitled to each year, like some benefit of 30 odd days, and that is counted as sentence undergone. So in some cases it might become 18 years, some cases it might become 50, 17 years undergone, total undergone. So remaining period they would have to undergo, and that is at least some 12, 13 years they would have to undergo more. Then they can apply under Maharashtra. Even today, Maharashtra government changes their policy. Still, what would apply is the one which was applicable as on the date of conviction. Conviction was on 28th of January 2008. So it would be minimum that, like that policy would apply, and that's why minimum 28 years have to be undergone. Now, as far as Shivani was asking something that is about remission policy in general, the question is not clear, but what I can gaze is this only. 1992, we had a very ritualistic policies for remission. Most of the states has 1.5-page policy, which bare minimum say 14 years undergone, and you can apply, and then the files to process. Now, the file, as per the jail manuals and the law, it requires that the jail authorities would have to start moving your file 6 months before completion of the minimum sentence. At that point of time, post 1992, most of the most of the states used to do a mechanical exercise, like it was done even in this case, mechanical exercise to deal with the applications. Most of the time, they would say no. But in Sangeet's judgment, State of Haryana versus Sangeet 2013 Supreme Court judgment, Justice Loku's judgment, it had said that, this is not done. It should not be a mechanical exercise. Sangeet took notice of Ipuru judgment of 2006, Maru Ram's judgment, and many other judgments which dealt with remission policies and the necessity of application of mind factors to be looked into, stated, and there has to be an informed decision about what you have examined, what is your say on that, what factors you have examined, and how you have come to say no or yes to the remission. So, and then post Sangeet, central government issued notification to all the states in 2014 January and asking them to revise their policies and to improve the policy. They sent the model policy also. And hence, most of the states then, improved their policies. Few improved their policies before. Luckily, Maharashtra always had, even their 1992 policy was great, a very detailed one. So the policies were revised in Gujarat case. In fact, they scrapped their 1992 policy in 2014. So what was applied to given remission, the policy had been scrapped in 2014, and they had brought in force 2014 policy. As far as other part of the Shivani's question was, this judgment becomes, you have many judgments on remission and not many otherwise also against the order of grant of remission. Most of the time you would find the remission has been declined by the state and accused had come to court saying my application has been wrongly declined. You have very few cases where remission had been granted and the victim in none of the cases, I believe, except Ipuru, had come to court challenging the remission. So this becomes in terms of landmark judgment, where it did a great job of sending 11 persons back, which has happened for the first time in history, where 11 in a bulk. So 11 in a bulk were never actually left out on revision also. So if that was a historical act, this is also a landmark historical act, and the 11 were sent back. This in itself a Bible judgment on remission, because it deals with all the law by the time available to the court, and then it gives factors which have to be looked into. It deals with section 432(7), where it says appropriate government and the procedure to be followed. So it has become it is one judgment which can be looked into, referred to, and you can deal with the revision thing. The whole, you always have to look for, as lawyers, the silver lining in each case, even in worst scenario. The Bilkis case has brought remission law on forefront. It was never discussed before in penal jurisprudence. We would talk about sentence, conviction, other things. But luckily, with all that discussion, remission has been discussed a lot.
Good evening, ma'am. First of all, sorry for that time you were asking me to turn on the mic, but couldn't because my daughter was there now. That's why. Ma'am, thank you. Yes, I understand what you have answered to my question. Ma'am, my next question is, if in their case of a breach of any of the condition of the remission, it will be cancelled or not?
Yes, the remission, like any other mercy or any other benevolent order, all orders, even the bail order, they are conditional. Conditions are attached to any of these decisions. So even remission, they have the conditions, and if you violate the condition, the order says subject to.
Okay, ma'am. Thank you. Ma'am, indeed, it's an informative session I have ever attended on the Bilkis Bano. Till the judgment come. It's the fourth webinar I'm attending on the Bilkis Bano. Indeed informative. Thank you, ma'am.
Thank you so much. Thanks for asking questions.
Ma'am, the next question is, so ma'am, it says that there were so many rape victims in that riots from both the communities. What's the major reason due to which this case got highlighted?
I don't know, like to my knowledge, not a single case of even attack for the other community. It was an attack on Muslims. So if somebody said both the community, I have yet to be informed of that. It was a case where the Godra rail incident had taken place, where the car savers, the train was burnt, Sabarmati Express. So Sabarmati Express there was a fire, people died. There was no allegation of rape, to best of my knowledge. It was, a counter blast or an attack on Muslims by actually, if you see this judgment, not this one, but the trial court and high court judgment of conviction, the evidence says that ye raya Muslim maro inko, matlab these are the Muslims, kill them. This is how even on the day one, from 27th of February, the Muslims started running and leaving their colonies because they were selectively picked up and killed and attacked. So, to best of my knowledge and whatever papers I have seen so far, this Gujarat riots were all about, like in Delhi riots. Delhi riots also, there was no attack on any Hindu. Most of, like a few areas, yes. In Delhi, there were. In Delhi, in fact, Hindus' houses were also burnt, but very few. But in Gujarat riots, there were Muslims only who were attacked. Yes, you are right that there were many rape cases. And that's why there were many trials. It's not one trial alone. Not all and many cases reached to Supreme Court. In fact, recently when these persons got remission benefit, there were other cases also where they discussed remission and court was extending. There are few cases where the bail was being discussed. So all sorts of cases. Yes, each single of the case should have been highlighted and should have got the limelight as Bilkis case has got. But then depends who has fought what case with what perseverance, who includes the victim as well as the lawyers, both. Now we do not know, like there, you might not be aware, but there are many cases the bench itself was dealing when we were doing this the Bilkis case. We used to have long list of 3 pages where all the cases were there mentioned, and Nanavati commission was appointed, and investigation was done. All that was done all for all those cases, not for Bilkis case. Bilkis case was having its own track. The only intelligent thing we did is we kept this matter separate all along. We had a very distinct way of pursue the case. Then many cases were in one basket and were being dealt by the Nanavati commission. I'm not aware that the commission was there for a quite long time, more than a year or so. That means they were dealing with thousands of cases, not one. And the compensations were given, dealt with, punishments have taken place. This is one case where there's 100% conviction. And it reached to its finality in terms of conviction as well as now remission, which other cases might not, like they're all cases, but not every case depends what fate and how it has been pursued. And then the nature of crime. Possibly because in Zahira's case, the best bakery case, the bakery was burnt. People died alive. But because they died alive, there was no rape was there. But there are cases of rape as well. I wish every such case would have got a limelight. But this is how things are.
Ma'am, we have some other questions as well. And ma'am, they are saying like, did you face any threats while handling this case?
Never.
And what's your message for other survivors of sexual violence who are seeking justice and still healing?
Keep fighting. Like when these 11 came out on remission, one of my client who is also fighting out a case of being raped by someone known, she said, then what is the point of putting all that hard work, showing it's very difficult to get your complaint registered, to be converted into an FIR, then FIR to be converted in charge sheet, the accused being sent jail. It's all very difficult. It doesn't happen very easily, and she's facing all that difficulty. She faced difficulty because the person was of high influence, so she faced difficulty even getting her FIR registered, complaint to be taken up by the police. So she said, why I'm putting up all that hard work, because if a matter of this nature can take this shape, then let's forget justice. But there are few decisions we have to make in life. If somebody has done some wrong, easy way out it to forget it and just live your life. But then you have not got the person punished, and you have not done justice to yourself. So if you have to do justice and make sure that the person is punished for the wrong he has done with you, and person is punished so that a message is sent, people are made aware about such people around, and then he is not been left free to cause such kind of harm to others as well. So things have to be pursued to a logical end for many reasons, many purposes. One must have to pursue it very diligently, without fear, without any kind of complacency. Fear, it could have been a case that I've been threatened. I have been not only threatened, but attacked in several ways in another matter, not this one. This I never been, even contacted. Bilkis matter, I've never ever received any threat, but another matter, my whole office suffered. That was again the person of a huge might. But then that's it. So be it. You have to choose your path and you have to take your call. It's difficult to say no to the person who is a victim and coming to you by saying, I am afraid of. You can't see your face again in the mirror. You just can't face yourself. You just can't respect yourself. So if that is not available, if that option is not available, then the only option available is to pursue it. And when you have to pursue it with all your guts. So never go overboard. Like in Bilkis' case, so many people wanted me to do this, that, theatrics, or maybe nobody suggested me to do the theatrics, but when they are talking, actually they are doing theatrics, you can understand. But then I had been very level-headed and in my approach, like a law student, have all those boxes ticked. Read your papers well, prepare it well, supported by law, have a very good preparation in terms of presentation to the court, make sure you're not wasting court's time and repeating anything, and then putting everything bang on so that it's being registered by the court. The moment you do a lazy work, your arguments are not impressive and it's not going to be registered and remembered by the court, and then definitely the judgment would never be as uh, as you want. So do our job very, very properly. In another case, when I'm saying I was attacked and my whole office was attacked and I really suffered threats and whatnot, I'm not naming to whom I met, but I met people with good positions in a profession, and I was suggested, why don't you ask for, security? I said, as for security, that means I'm actually having, I would be paying for them, I would be feeding them on the daily basis, I would be arranging accommodation. You all must be knowing that if you ask for security, you have to arrange the logistics. So I said, I would be doing all that, and then I would be having informer roaming around with me. So who does that? So there are ways of dealing with things. You can't be hiding your neck under the earth and then doing your job. It's not done. Face it. Face it with guts. Face it in the front. And life is never minus risk. You drive a car and you are facing a risk of accident. You're walking and you are facing a risk of fall. Right? We are eating and we are facing a risk of indigestion. Let it be. Amresh is very happy, huh? Okay. Yeah. Anything else?
Yes, ma'am. One last question, like regarding the remission committee, which actually passed this thing. So, ma'am, can we have prosecute them, or there is some kind of accountability on the committee that some measures can be taken to avoid this in future?
Now, when you said can we, right? Now, who can this we be? I always say that, the first responsibility under a constitutional system of ensuring a citizen that you are in safe hands, in safe environment, in a safe state, and that law and order would be maintained and you would be protected against all odds, and your wrongdoer would be punished as of a state, and that means by police. Right? That's why all crimes which are not vis-a-vis A versus B, you have the nomenclature as state versus A. So state becomes a prosecutor for yourself. And if somebody does any wrong or departmentally somebody does, then departmental action has to be taken by the employer. And if somebody is a state employer, then by state. Here, when this committee, who as per section 432 and GN manual, a committee for remission applications to be considered, and recommended remission, who all fortunately, unfortunately, in their first round, the same accused on the same fact sheet said no for remission, granted remission later. But then the file went up to state, based on the recommendation, state recommended, They sent a recommendation to the central government and central government approved it. Now, assume for a moment the state can be given, a benefit of doubt. The central government can be given a benefit of doubt, but certainly no benefit of doubt can be given to the committee. Supreme Court, in so many words, said that the decision of the committee exercising their power, rather abusing their powers so mindlessly, and then a fraud was played upon Supreme Court. Uh, both are wrong, and that's why remission was cancelled. Supreme Court has said everything in so many words, minus or barring one last sentence, say take action. But for state, this should be good enough. The highest court of the country is reprimanding the functionaries, the person involved in the process so heavily. The government must take action. The government must set an example. No, Amit, I would not say it was planned. Okay, I don't do an advocacy of such allegations of deliberate attempts. There's always a way to say things. So when I was arguing, I said that it appears, and you have to take it as a lawyer from me, some these kind of things we can do, say and not say types. So I said it appears that the decision was already taken and papers had to be filled in later just for the sake of formality. I could have said it differently also, but I thought this is the only proper way for me to just say it and not to say it.
Okay, ma'am.
Garlanded, I just missed the name. I could see the question flashing. We all came to know about the remission, and these people came out on a premature release only because of that function or that, celebration. And I'm so thankful in terms that they did. That was so obnoxious, so painful. It was, heart-wrenching to see even that somebody, a society can garland and felicitate and respect and, touching feet and whatever, whatnot. But only because of that, it received so much of the highlight, and that public outrage. So it in a way played a role. It in a way helped the process to be that big that everybody was so agitated. Assume for a moment that they didn't do this, and these rapists came out and hiding, or maybe living in some secluded place, and 6 months down the line we would have got to know. It would have been very late then. Sometimes, as we say that the criminals leave some proofs or some evidences behind them, or that all wrongs do leave, all crimes do leave some evidences behind. So this was also, when something is so obnoxiously wrong, they pave ways, they give themselves a reason for things to be highlighted and to be followed up. I missed a few more questions. They were just flashing in and.
Yes, ma'am. So, ma'am, one we just received is for all the law students who dream to be an apex criminal advocate.
So first dream should be to become a good lawyer. And to become a good lawyer, I firmly feel, and I'm, illiterate on that count, that I have never practiced in lower court. And I firmly believe that we must practice at least 6 months in the first court. Learn all the nuances. So have the foundation and then start building it up. Give yourself few months or a year in trial court, then at least a year or two in high court, and then come to apex court. So you have your foundation very strong. You have seen people coming directly to the last court and then carry the brief only. Like, it's become difficult to become a lawyer then in that terms, and you are actually learning the art. And secondly, you have to be very basic in your approach. need not to be very flashy, need not to be like, okay, I'll just do that. Uh, hard work in terms of doing everything yourself. Like we used to take dictations from our seniors by hand. And so it would, work on a memory. We would remember whatever we have taken notes of. We'll sit with them, we'll read the files, make notes, do the typing, what not. We have done everything. We have done the file making, what we have done everything. We have done work with our clerks also. When it's face threats, how do you deal with it? Try to ignore the threats first. When the threats are surmounting, like I faced when I once came to my office, all my connections in terms of telephone connection, light connection, water connection, all wires were cut. So one day was like that. Another day I was coming out from my office, my residence to go to court, and somebody came and banged my car with 150 speed. And I had a very heavy German car, so I was not crushed. But my car, the door was jammed. I was in between it. So what do? I just clicked the photo of that car. I said, "Abhi to court jana hai." I had a matter in NCLAT. I couldn't come out from the car because the door was jammed completely. I came to my office, took my gown and everything, went to NCLAT. I had an early matter. I went there, and the army person standing there because they have their offices in NCLAT, that complex where we have had NCLAT then. So one of the army officer asked me, he said, who was driving this car? I said, I was driving this car. He said, but you were sitting in the car when this accident took place? I said, yes, I was sitting on the driving seat. He said, still you're alive? I said, yeah. Looks like I still had life. So, and he said, still you have courage to come and argue the matter? I said, yeah, that's my job. Like, I have to. So I went to argue my matter, came back. In the night, went to the police station, lodged FIR. So, I could have gone into a shell. I did not. I weighed the things, take very wise decisions when you're facing things like that. Don't go very over smart. Don't be very over courageous. Don't get into the shell. You have family around. You have things around. Think about everyone. Still continue to live as a lawyer and be able to face yourself, like face your face. That's something very important you have to do. And जिंदगी ऊपर वाले के हाथ में होती है फाइनली. तो जब जानी होगी ना, घर पे बैठे बैठे सीट पे बैठे बैठे हार्ट अटैक आ जाएगा. सो यू डोंट नो. But as Aparna was raising hands, who needs to take the step for prosecuting? What is that? I didn't get the question.
So ma'am, basically, what I suppose is like they're asking for, like, if some steps that we all can take to prosecute the revision committee now, or any state action or something.
You can file a PIL. One is somebody can go to Gujarat High Court filing a writ petition under Article 226 and asking the Gujarat High Court to issue directions to the Chief Secretary of the State and Home Ministry to take appropriate action, disciplinary action against the committee members. That is one step. Another one is one can directly come to Supreme Court, but Supreme Court can still entertain, depending, when it comes to the judges and what they are doing. But either of these actions can be taken. But a writ petition. And how do we get the locus? You have many judgments on locus which are cited even in this judgment, that a crime of this nature or a wrong of this nature is not against an individual. We, the entire country, not only suffered collective pain because of the wrong decision and the deliberate decision, but we suffered a collective shame also. The country's reputation had got down, and I faced so many interviews and questions when I never said anything against our system, but the fact remains we were looked down.
Thank you so much, ma'am. Like this session was really, really insightful, and
Thank you so much, ma'am.
your ideas led us to delve deep into the world of knowledge and understanding, and accepting our invitation to share all the expertise and vision. It is our honor to have you and illuminate our minds and inspire us and all the attendees here. Thank you so much, ma'am, for being here with us
Thank
today.
you. Thank you. I
Uh,
enjoyed being here.
Thank you, ma'am. Now we have with us Vishakha Kaushik, the President of Delhi Judicial Reforms Council. Vishakha is a fourth year student of law specializing in intellectual property rights. She has been working with the National Judicial Reform Council since August 2020 and has left no stone unturned to foster the growth of DJRC in capacity of a president.
I've seen. I'm so sorry for that. What you can do is send me the questions. I'll actually reply them back. This is what I can do. Any, anytime. Like when I was in your age, I would be loving to, see somebody coming forward and talking to us. So if any role I can, little bit, whatever I can play a role, if that can help any one of you, would be. Mhm. Cool. But, that's not because of me. That's for Bilkis' name. That name does wonder. Thank you. God bless you all. All the best for your bright future ahead.
Thank you so much,
Bye
ma'am.
bye. Bye bye.
Thank you,
Thank you.
ma'am.
Thank you. Thank you, Shreya. Thank you, Vishakha.
Ma'am, where will we get our feedback forms?